law school. Butler Yates was a fairly old firm, but the lawyers who recruited law clerks were young and were more inclined to talk about the firm's website than about its traditions. That's why I didn't know until that Monday morning, my first day on the job, that Bobby Jones had been a partner in the firm. That's right, that Bobby Jones, the man many called the greatest golfer who ever lived. I knew enough about him when I learned about it to be impressed, but that was about it. Certainly not as much as I know now. But I'm getting ahead of myself. The subject of Bobby Jones actually came up as a way of introducing me to my first project. You have to understand, there's not much first-year law students can do as summer clerks. The first year of law school doesn't cover much more than basic concepts of torts, contracts, criminal law, and procedure. As a result, first-year clerks are more window dressing than anything else. They can't do more than the simplest research assignments. Maybe shuffle some papers or organize files, run to the courthouse to file pleadings, catalog documents being produced during discovery, that's about it. For this reason, law firms don't hire first-year students for what they can do. The real reason they hire them is to get a foot in the door to recruit them after graduation. Thus, in reality, the salaries paid first-year clerks are really seed money. So when Charles Hunter showed up for work that first summer after just 1 year of law school at Tulane, the partners at the firm weren't expecting much. Of course, no one admits this. They're much too polite for that. Besides, there's no need to risk offending the recruits with such candor. Unless they have IQs lower than mayonnaise, they'll find out soon enough on their own. At least, that's what happened in my case. It didn't take me long to realize how little I knew. I just watched what the lawyers were doing and saw that it was over my head. So when the firm went looking for ways to keep the otherwise worthless first-year clerks busy, someone came up with the bright idea that one of us could be kept occupied the entire summer cataloging what was left of Jones's files. Not that they expected to come up with anything sexy. Jones had written several books during his lifetime sharing the great events of his life and his secrets about golf. When he died in 1971, his family and friends inherited a treasure trove of trophies, medals, and other memorabilia. The only things left at the firm were his legal files, which were protected from publication by the attorney-client privilege. Besides, they belonged to the law firm and its clients and could not be inherited by Jones's survivors. At any rate, the public never really cared all that much about Jones's legal work. It was his golf that interested them. Over the years, most of the files became scattered as other lawyers completed work that had been in progress when Jones withdrew from practice. Many clients, conscious of the value of anything with Jones's signature, wanted their files and so took them from the firm. Fred Nathan, the partner who seemed most responsible for keeping us busy, tried to make my assignment sound important, but I saw it for what it was. Not that I minded. It would keep me busy, and it was not something I was likely to screw up. Just the ticket to get me invited back next summer, if I wanted to return. That, it seemed to me, would depend mostly on the number of Braves games I was invited to attend. Nathan was an interesting guy. He was reputed to be a genius at securities law, and had allegedly spent virtually his entire career drafting, editing, and reading the fine printed disclaimers contained in prospectuses, or could that be prospecti, circulated as part of initial public offerings of stock. Nathan certainly gave the appearance of having suffered severe eye strain for his labors. He wore glasses so thick they reminded me of Roy Orbison. If they had been tinted green, I would have expected to see the name of the town in which Coca-Cola was bottled written in a circular fashion along their outer edges. At any rate, Jones's remaining files had been put in boxes that were stacked in a single room just off to the side of the library. The room had no windows and bare walls that needed fresh paint, hardly a shrine to the man who retired at age 28 after winning the 4 major championships of his time, all in 1 year. The drab, brown carpeting suggested that the room had once been used as an office or for conferences, but not recently. There was a small table with a computer. It had been loaded with a software program designed to organize document production in litigation. The indexing system was simple enough. I could easily use it. In the beginning, the work seemed pretty